Thanks, Mr. Chairman, and thank you for your service, Mr. Mathis, and your willingness to serve in this position and your very distinguished record as a litigator. I want to say first that I know that the issue of blue slips is going to be raised perhaps during this hearing. This committee abandoned the idea of blue slips for circuit court judges under 4 years of the Trump administration. I think it's an issue that shouldn't concern us, and particularly with a candidate of your qualifications, need not concern us. And I hope that the committee will focus on those qualifications rather than on the blue slip issue, because I think it's really the relevant one before us now. And in that connection, let me ask you, because you have done litigating as a defense attorney in criminal matters, what is it about that experience that you think will give you a perspective and background important to you as a judge on a federal court of appeals?
Thank you, Senator, for that question. As you know, the Sixth Circuit hears both civil and criminal cases. I believe in the last 12 months or so, the breakdown has been 40% criminal and 60% civil. And I have pretty significant experience in both of those, having litigated over 100 cases in federal courts in Mississippi, Tennessee, and Arkansas, both civil and criminal. As part of my criminal practice in federal courts, primarily as part of the CJA panel, which is I take court-appointed cases and represent individuals who can't afford counsel, which is required by the Sixth Amendment. As part of my criminal practice, I've also represented victims and witnesses. So having those different perspectives, I think will help me to get up to speed. Having those and having experience also with vast areas of civil practice representing both plaintiffs and defendants, individuals, governmental entities, and businesses in those type of cases gives me, I believe, a good base if I'm fortunate enough to be confirmed to the Sixth Circuit.
Do you think that there is an obligation on the part of the bar to provide representation to criminal defendants?
I believe so. I mean, it's enshrined in the Sixth Amendment that individuals have the right to counsel even if they can't afford counsel. That's what the Gideon opinion was about. And that's something that I always felt that was going to be a part of my practice. Shortly after I started practicing law, I took appointed criminal cases in state court, and then later began taking appointed criminal cases in federal court. So I believe it's important for lawyers to do that, and that's why I've done it throughout my career.
I agree with you completely. Even though I've never been a public defender, I believe very strongly in our public defender system. As both a federal prosecutor and state attorney general in Connecticut for more than 20 years, I respected and admired the people who devoted their lives to that part of our profession, and I am really very proud and glad that the president has decided to give more opportunities for the defense bar to serve on our courts, because they do bring a perspective and experience that is very, very valuable, and they create more diversity in the viewpoints that are reflected when judges go into those conferences and they decide what to do on appeals, or when an individual district court judge decides what to do in the trial before her or him. So I want to thank you for the work that you've done and the distinguished litigation career that you have, probably as good as any we tend to see in this committee in terms of the diversity in the background that you would bring to the federal courts. So thank you very much for your service. I look forward to supporting you. Thanks, Mr. Chairman.